So Kishore, maybe you can join. Richie and Mansi will continue for a while, very quickly, because we'll go on to discuss hedge fund and the landscape for portfolio investment. I think that is again, so as soon as the phone is connected, maybe we'll spare a little time to listen to Mauritius' call, and then we'll continue our panel as well. So it would be good. Are they connecting? What have?
Yeah, that's
Achha, okay. But on that number, no?
Yeah.
Okay, fine. So let's go on, so we don't have to wait the moment. So Kishore handles our hedge fund practice, and I just have some question for you. How is the regime for hedge fund is shaping up, what you call FPI investors now, and are there any issues that you see? What kind of problems you see?
Sure. So as you all may know, SEBI had introduced this FPI regime in 2014 by repealing the earlier FII regime. And it's almost 2 years that these new regulations are in place. And definitely they are shaping up well in terms of the registrations that we have seen. In fact, the important thing that has happened pursuant to introduction of the FPI regime is that they have created a new category for non-institutional investors. Earlier, in the FII regime, only the broad-based players could register and make investments, portfolio investments into India. But SEBI has brought this new category, whereby now even non-institutional investors like corporates, family offices, or for that matter, individuals also now could register and make portfolio investments into India. And that has helped a lot. And of course, as the earlier panel members has indicated, is that SEBI's main object always has been to get as many investors make direct investments into India, so that SEBI can have a supervision, direct supervision over these investors, instead of they coming through or using some different structures like ODIs. The other important thing, of course, is that while SEBI has introduced this new regime, they have grandfathered all the earlier registered entities till the date of its expiry, so that gave some time for the existing FIIs and the sub-accounts to continue in the same way as they were regarded as deemed FPIs and could continue the way they have been doing under the old regime. Of course, the unregulated entities now, or even for that matter, regulated entities are primarily the investors who want to invest into India and get registered. Could do it on their own by making the registrations, and they don't need a sponsor manager to assist them for the registration.
Are we ready for the call? Yeah? Sorry for my interruption, Kishore.
Sure, no problem.
I think they're calling from Mauritius.
Hello.
Hello, Harvesh. How are you?
Nishith Desai, how are you doing?
Very good. Thank you so much. And thank you for coming online at this point in time. So really appreciate. I know it's late in the night, and but I think everybody is anxious to hear your views and your news and all that is happening out of Mauritius. Please let us have your talk a bit here.
Certainly. First of all, I'd like to present the apologies of the Honorable Minister, Roshi Badin, who was supposed to be speaking in via teleconferencing today, but he's unfortunately being held back in a night session of the Parliament. It's still going on. So he's presented his sincere apologies, Mr. Desai, to you and certainly to all the participants. He was really looking forward to engaging with you and really share some of his views in terms of some of the latest developments that are happening our end with respect to India-focused businesses that are going through Mauritius So apologies for this and for him not being able to make it. But just briefly to introduce myself very quickly and the organization that I'm heading. The Financial Services Promotion Agency is the government agency of the Republic of Mauritius. And we have been entrusted with two key responsibilities. The first being the development of the financial services sector of Mauritius, and certainly, secondly, the promotion of Mauritius as an international financial center for the region, primarily for emerging markets, and very much that includes India, which brings us really to the crux of the discussion and to the crux of the topic that is on the agenda for today. And here I have to certainly commend Mr. Desai for this excellent initiative that he's been organizing year after year, really. The Lifecycle of India-focused funds has, as I understand from many players in the industry here in Mauritius and abroad, has now become a key event for them to engage and really share views about strategies with respect to investing in India. And it is in this very respect that, you know, when the new government took office, it's been like a year and a half nearly now, it was very high on the agenda that, you know, the uncertainty element that was really looming around and looming on Mauritius as a financial center with respect to investing in India, that uncertainty be addressed. And that was high on the agenda, and this is what has been done through really the newly signed protocol to the India-Mauritius DTAC that was signed in May earlier this year. Now, the protocol, as I'm sure you're all aware of its content basically, came at a very opportune time in terms of, as I said, bringing in that clarity and bringing in that certainty in the use of Mauritius as a jurisdiction. But more importantly, it was very important for for us here in Mauritius to ensure that, you know, number one, there is the protection of all existing investments as well as structures, as well as new structures being formed up till 2017. And this is what has been achieved through the grandfathering provision that has been negotiated. It was also very important to ensure that there is no abrupt changes that is brought about, you know, in the use of Mauritius as a financial center for going to invest into India. And this is where, you know, it was very important to negotiate a phasing out approach. And this is, you know, we must say that we are lucky that, you know, the Indian government has finally agreed to provide Mauritius with a 2-year transitionary period in this regard. And thirdly, it was also important for us to preserve our competitiveness as a key destination and as a financial center for all that is debt structuring really out of Mauritius, which is really the new trend that we're seeing in India as well. And hence, we, under the new protocol, the government has been able to really negotiate and secure a very privileged, I would say, rate in terms of debt structuring. So all this really has been done in a view of, as I say, bring more certainty and clarity to the jurisdiction. And we are already seeing some key developments. We are already seeing the statistics that are showing that confidence in Mauritius as a financial center for going to invest into India is back on track. If you look at some of the figures in terms of new structures that are being created in Mauritius, in terms of investing into India, we have seen a surge of 35% just for the month of June this year, basically. So that explains, you know, that as soon as, you know, the new protocol was announced in May, basically, Although there was some, I would say, confusion, most probably in the first few days, but soon after, confidence has been achieved in the use of Mauritius as a financial center, and the figures, as I say, are speaking for themselves. And more importantly, as we compare with ourselves with other jurisdictions, as we speak today, basically, Mauritius remains the most certain and the most competitive financial center for investing into India. I mean, not later than today, the Economic Times in India has come up with a series of articles saying that following the newly negotiated treaty that there is between India and Cyprus, that has led to quite a flight of private equity funds now coming into Mauritius instead of structuring in Cyprus, basically. So we are very optimistic that the certainty that has been brought through this new protocol will really put Mauritius again on the map, as it has always been, really, as a key financial center for driving investments into India. I think with these words, I'd like to certainly take on any questions that there may be from the floor. Most probably, I will stand guided by Mr. Desai on this one.
Oh, no, thank you so much. Yeah, we have one question from.
Hello, my name is Dhruv Sanghvi. I'm an academic, and I'm fascinated by the renegotiation of the India-Mauritius tax treaty. What has caught my attention is that the taxing rights have been allocated to India only insofar as the capital gains arise from the alienation of shares in a company. So interests in an LLP would most likely not be covered by shares in a company. And there is commentary to this effect in the OECD model and also in the UN model as to countries that want to avoid this sort of a situation should negotiate their treaties differently. I was wondering if Mauritius was aware, or if this was really the intention, that the renegotiation applies only to shares in companies and not to other forms of securities and other forms of entities that are invested into, for example, an LLP.
Thank you, Drew, for this one. I think we have to look at it from various angles, to be frank with you. One of the factors that really pushed towards the renegotiation rather to the signing of the new protocol was the two things. One was the fact that the ETA that we have with India was signed back in 1982, as you're all aware, and after so many years, over 3 decades of existence, there was the need, most probably, for revamping the ETA or for looking at it and bringing in changes. Now, when we talk about changes, certainly there have been some concerns that had to be addressed by India. And really, the renegotiation has been done in a way that addresses really the concerns of the Indian government primarily. At the same time, ensuring that we safeguard our interests, as we've always been saying it, that any negotiation has to reap to a win-win situation for both countries. Now, what has happened really in the negotiation, therefore, is the fact that the concerns of India has been addressed in the sense that whatever concerns were brought on the table by the government of India have been addressed, but at the same time we've made sure that we preserve our interest, and it remains a win-win situation, as has been the stand of Mauritius all the time.
Yeah.
Thank you.
Yeah. So I think ultimately bilateral trade negotiations are matters of give and take, and both parties know what they are doing, And once it is done, then one has to implement the treaty in good faith, as what has been stated. And that's the thing. Harish, other question is that in light of there being incorporated LOB article in the treaty, some concern is whether GAR could still be invoked. Of course, Pathsati Shom Committee and general view has been that if there is LOB article, then GAR cannot be invoked. And if you have any thoughts on that or anything.
Certainly, as far as my understanding really is on this one, Mr. Desai, to be frank with you, I mean, and here I can always, submit further inputs in this regards to you that can be shared with the participants in the room. But as far as my understanding really is, and discussions we've been having so far in Mauritius with the various actors, it is understood that the LOB would be prevailing.
Correct.
This is the stand that we all have here in Mauritius.
Okay, fine.
Yeah.
Any other question? Yeah.
I think, Mr. Desai, if you allow me here, I mean, certainly, would be more than happy to engage with participants who are in the room. I mean, I myself, together with the minister, we were supposed to be there with you today, but unfortunately, there are developments that are happening in that were really unforeseen. Having said this, what we can propose really is certainly, Mr. Desai, if you'd be agreeable, is for you to share our contact details with, most will be by email, with the participants, and if ever they do have further questions with regard to the use of Mauritius as a financial center, especially for India, would be more than happy to address to their concerns.
No, thank you so much. We really appreciate your taking time off at this late hour in Mauritius to be with us, and we'll certainly stay connected. So I just want to thank you so much, and we can give a round of applause, at least you can hear that.
Thank you. It's always a pleasure. Thank you so much.
Absolutely. So
thank you.
Absolutely. I think there's a lot more bright future ahead of us, and we'll take it forward here. Thank you. Okay. So I think we now move on back to the hedge funds quickly.
Sure.
And then after we'll be talking about private equity as well. So can we get back? So Richie, what are your thoughts on synthetic participation, through derivatives, and where are we finally in respect of eligibility criteria to subscribe to ODIs?
Sure. No, so I think just to introduce ODIs or offshore derivative instruments are synthetic participation structures like swaps, TRS, etc., which are used, for a very easy, fluid, basis to access different markets while engaging with very limited counterparties. So, instead of, directly holding shares as a foreign portfolio investor, where you need to engage a custodian in India to take custody of the Indian securities, where you need to file tax returns in India, etc. As an ODI holder, you are holding a swap position. It is technically the issuer, which could be any of the lead guys on the street like Goldman, Citi, Morgan Stanley, etc. You only engage with them. They are the ones who are holding the hedge positions. They are the ones who are doing all the filings, all the reportings in India. And the onus is on the issuer to ensure that they also report on a monthly basis who the beneficial owners of the ODIs are, etc. I think it's a very simple mechanism for somebody who's doing a global allocation of investments across liquid investment strategies to look at ODIs. So that is one way of looking at the product. I think some of the recent discussions that we have been reading from the industry participants has been around who is ultimately eligible to subscribe to ODIs. That is where the government, their whole perception that they don't want synthetic exposures. They want investors to directly come and invest in the Indian markets. What they have been doing is that while ODIs could previously be subscribed by unregulated entities, as long as they were broad-based or were managed by entities which were appropriately regulated, or they were directly regulated by a securities regulator or an ordinary member of IOSCO. IOSCO, just for your reference, is a global commission where all the securities regulators are a member thereof. So all those could access ODIs. What the government has now done is it has limited ODI subscription to only those entities which are directly regulated by a securities regulator, and that the securities regulator has to be a member of IOSCO. What it means is that if, let's say, you are a New York based fund or a Delaware fund, and because you are not regulated by, let's say, SEC, which is the federal securities regulator and a member of IOSCO, you may not any longer be eligible to subscribe to ODIs. On the other hand, if you're a Cayman based vehicle and you are regulated by SEMA, which is Cayman's securities regulator, then that pretty much allows you to access ODIs, which is where we see a lot of disparity, despite the apparent mismatch of how the regulatory overview is there on different entities. A Cayman-based entity being eligible, whereas a Delaware or a New York entity not being eligible, has thrown open a lot of questions and challenges for investors who look to access ODIs. And that is where we see the government has clearly been tightening the clamps around ODI participation. Obviously, it means to encourage direct investments into India, but clearly this has given more things to think about when you are accessing India.
In fact, sorry, just one point to add to what Richie has been talking about these regulators. Under the FII regime, initially the SEBI did not, of course, define as to who is the appropriate regulator. So what they used to actually exercise is that any regulator which is the ordinary member of IOSCO would be regarded an appropriate regulator. And interestingly, the CFTC, which is a commodities regulator, was also an ordinary member of IOSCO. And SEBI had to, in fact, accept and register some of the entities which are regulated by CFTC as the FIIs and the sub-accounts. Now, what has happened is under the new FPI regulations, SEBI has clearly mentioned the securities regulators. And that's where now the issue that is being faced by all these entities which are registered with CFTC, that they going forward may not be able to either register or continue to subscribe to ODIs.
Yeah.
And on this actually point, Kishore, if you want to talk about one of the issues we've been working with is for banking regulators as far as US state banks are concerned, and we've been actually representing to SEBI on why they should be getting, it's not, actually that is not just a question of ODI, but them getting category 2 registrations, right?
Absolutely, because in the USA, it's apart from, of course, the main banking regulator, there are the state regulators, banking regulators also. And most of the collective investment trusts, CITs, are generally managed by these banking entities, which are regulated by the state banking regulators. And that's where they actually, and to a certain extent, they are kind of supervised by the main federal banking regulator, as also to a certain extent by the SEC. And that's where we are kind of trying to fight with SEBI as to.
And in spite of that, actually SEBI is not pushing their registration application through. But we've been trying to work with them, pushing it, that explaining why these should be considered as appropriately regulated.
That's good.
Yeah. Mansi, I may just turn to you, and how has the protocol, of course we talked a lot about it, but has it impacted FPI and then diverse strategies?
I think there is limited impact if we just look at the protocol, simply because as we've discussed, it depends on the security or what the investment strategy really is. To the extent there's exposure to equity shares or basically shares in Indian companies, yes, the protocol impacts FPI, but again, we have to remember that a long-term strategy is anyways you're not taxed in India. As long as you pay a securities transaction tax, you have zero exposure, zero tax in India. So where it is really impacts is those who are going to get short-term gains from shares that they are holding in Indian companies, because that is going to be taxable at 15%. If it's on the floor, if it's not, then it could go up to 30%. And there it becomes interesting whether it actually makes sense for an FPI to continue the structure that they actually have in these jurisdictions, or maybe look at alternates. But as opposed to PE investors, at least the 2-year period which has been provided under the treaty for getting a 50% beneficial rate if you meet the limitation of benefit clause, which is another requirement that you need to consider whether you can actually meet that clause, you will be able to get that benefit for use, because for listed securities, to become a long term, it's a shorter period. So I think there's limited impact. The important thing is, in fact, for Singapore funds that are there, because the treaty is going to go right now, we don't have clarity whether that will also just be applicable to shares, or will it end up covering the other securities also, and that we are yet to see. So that becomes, that's open for discussion. We're expecting that the protocol should be announced soon, in any case before the end of the Indian financial year, so we'll see.
And but would you want to say something on the place of effective management, but very quickly?
Sure. And this actually, place of effective management is a concept that affects not just funds but other industries also, in the sense that what they've done is India's changed its rules on when a foreign entity could actually be considered to be resident in India. It basically says earlier you had to be wholly controlled and managed from India. But now what they've said is that if a foreign entity, if a place of effective management, a POEM, is in India, then you could be considered as an Indian resident. So this becomes important when you have Indian teams, and if the Indian authorities see that you're actually involved in the decision making or running of the foreign entity, then you have that exposure, and that's actually then they deem you to be an Indian resident, and you get taxed on pretty much everything at Indian tax rates. So when you're looking at these structures, we've always had a permanent establishment risk. But for that, in order to promote the onshore domestic industry, they did come out with safe harbor rules. So if you met the criteria of being an eligible fund, and then you had a team in India or a manager in India, they said we wouldn't say you have a business connection, and we wouldn't treat you as having a permanent establishment, and you could be out of that. But this risk of having a place of effective management still continues, and there is an exception as such to it.
Kishore, one small thing. Is there a clarity on NRI participation in FPIs?
Well, yes, the same restriction actually continues as was there under the FIR, for the simple reason that there has been a separate category of NRIs. The only problem now what has happened is pursuant to introduction of FPI regulations, where, as I earlier explained, they have created a separate category for non-institutional investors, whereby now foreign residents can register as category 3 FPI and make investments up to 9.99%. NRIs still continue to make investments only up to 5%. To that extent, they are still at a disadvantageous positions, and that's why actually SEBI now should consider, or the government, that they should merge this separate NRI portfolio regime into the FPI regime and allow NRIs to invest along with the other foreign investors up to 9.99%.
No, thank you, Kishore. At this point in time, if there are any question, or maybe Aishwarya and others can join on the panel for the next one. Any question anyone has on FPI?
I do actually.
Yeah.
In terms of the new SEBI requirements that you have to drill down to the beneficial owners, how is the SEBI considering an open-ended fund where it's very difficult to establish who the beneficial owners are as they change on a daily basis?
Right. So I think you may appreciate that earlier there was vacuum on how you conduct the beneficial ownership test, the KYC standards. There was a particular point in time where the KYC, there was a debate whether it should be that of the jurisdiction where the beneficial owner or the holder of the ODI resides, or should the KYC standards be followed of the jurisdiction of the issuer of the ODI. So there SEBI came back, and now it has been formalized that you have to follow Indian KYC standards, which is under Prevention of Money Laundering Act of 2005. That says the legal basis of the KYC standards. The second issue that you sort of highlighted was that what if it's an open-ended fund, which is the beneficial owner, then how do we track that from a SEBI perspective? So there, clearly the circulars have indicated that as long as the issuer has a system or a program in place to track the KYC of the beneficial owners, SEBI is not going to probe any deeper unless it has reasons to. Let's say the open-ended fund that you were referring to only has 1 or 2 investors, it's very thinly traded or something of that sort. Unless the trading or the open-end platform is somewhat a sham, you need not go deeper than a fund structure. Or frankly, if you're a listed company, then you need not track who the individual shareholders are, because again, that can be traded on a day-to-day basis. So there is a finality to where the KYC would stop, and beyond which the regulator won't probe how diligent you have been on the KYC.
And I'm sorry, I have one more question. With these new regulatory changes, ERISA funds are no longer eligible. Has there been talk by the SEBI to consider ERISA funds regulated, since they are very regulated in the US?
Actually, what moves the needle for the regulator in India is not the fact how heavily you're regulated, but who is your regulator. Unfortunately and clearly, SEBI has been taking a lot of comfort. If you're regulated by a securities regulator, not only in case of direct investments on FPI front, but even on the ODI side, because clearly they have seen that there are a lot of gaps on the issuer's side when they're issuing ODIs. There are a lot of representations that everyone relies on as far as the industry is concerned. So which is where SEBI just wanted to ensure that even if, let's say, there were gaps in the KYC being conducted, at least it can connect to the other regulator through the IOSCO platform and figure out whatever information it required. Which is why we think it would be very difficult to expect SEBI to again change its stance back to ERISA or CFTC or other regulators that we have been discussing.
Thank you.
Yeah.
Unless you can get the regulator to agree to provide information to SEBI. So there could be a bilateral, depends on your ability to convince the regulator to share, give comfort to SEBI that they'd be willing to share information. So it could be a bilateral exchange of letters. We are looking at opening dialogue with SEBI and other regulators in the US, state regulators who would be willing to come up with that solution, because that's the only issue that's the only real issue that SEBI has, that when they want information, there was this particular instance, it was a big case where SEBI asked for information from the issuers, and the issuer said, sorry, we are subjected to confidentiality obligations under our contracts, and we can't provide that information, and our regulator didn't like that. So that's where it stems from.
Yeah.
So we are happy to, help have that dialogue on the SEBI side. They're more than willing, in light of what we discussed in the previous panels, this government, including SEBI, is more than willing to have that conversation and find a solution, because they're looking for investors, if your regulator is willing to come up with some kind of a solution.
Yeah, I think let's thank the panel. Okay. Very quickly, thank you. Very quickly, Pratibha, why don't you give some update? And you worked on this first sovereign fund that you worked on. And why don't you come here and give a quick snapshot of what's about and what's happening, and how it is going to help other funds.
We have the slides up. So, the National Investment and Infrastructure Fund is going to be probably one of the most exciting matters I do in my lifetime. Simply, because the way it started, I actually got a call from the Joint Secretary, who is quite senior enough in the Ministry of Finance, saying the Finance Secretary, who's the senior most bureaucrat in the government, wants to meet you on a Sunday morning, not in his office, in this club, to discuss, a fund that the government's looking to create. And I fell off my chair. I first thought it was a prank or something that some friend is running on me, because that just doesn't happen in India. But it was true, and the finance secretary met us on a Sunday over coffee and said, "Tell us how trusts work in India." And it's a very loaded question, because before this government, trusts were actually very mistrusted in India. They were, the tax authorities didn't like them, the Ministry of Finance didn't like them. If any file went with a trust structure, it was rejected without specifically saying because it came through a trust structure. So it was quite interesting to me, like my ears completely popped up when he said, "Tell me, how do trusts work in India?" But basically, he was looking for setting up NIIF. Oh, there you go. And what the government, and this is again so much in line with everything else this government has been doing. And I'll make a disclaimer. I'm actually, quite liberal in my thoughts. So traditionally, I've always supported, Congress or some other left liberal parties. So doing this for the right-wing government has been even more interesting. But full credit to them for trying to think of innovative ways to boost the economy. And the main issue that they're trying to solve here is the infrastructure sector in India has been suffering because of lack of funding. We did the first round of experimentation with public-private projects. Most of them have suffered significantly due to delays, due to various issues, whether it's getting the necessary approvals or getting into bed with the wrong promoters in India. But for various issues, private investment in infrastructure sector, especially foreign investment in infrastructure sector, between the period of 2003 to 2010 really didn't work. As a result, most of the infrastructure long-term projects have been suffering due to lack of equity funding. And so the government basically called us to provide them with a structure through which they can solve for providing equity funding for the infrastructure sector. And this is something that we came up with in conjunction with them, where we set up, Nishith gave this term, a collective sovereign wealth fund, where it's kind of a matching program where Ministry of Finance is willing to put money where the mouth is, and invest in India's growth along with anybody else who wishes to. So the government has, through a cabinet note, put through the structure where they would put 49% of the investment, as long as we can raise 51% from other sources, mainly other sovereign wealth funds, to invest in Indian infrastructure. Why is this important? The way and the amount of focus, like if you just Google NIIF, you'll find dozens of articles on it, has gotten huge interest from the press and the community, because the target they're looking at is $6 billion as a start. And out of that, 3 billion would be the government, and 3 billion is all they have to raise from other sources. But that's just at the top. And then from that 6 billion, they would invest in projects where there would be other investors already, hopefully, and those investors would get attracted by the fact that you have money that is backed by Ministry of Finance coming in. So it's supposed to kickstart the infrastructure project, and we already have signed MOUs with the Russians, ARIA, QIA, advanced talks with Japan, And both US and UK Treasury have reached out to us, and also to the Ministry of Finance have signed bilateral letters for support. So, it's garnered quite a bit of interest globally in terms of providing India the support needed for building this out. In fact, with Rus Nano, we are right now at a term sheet stage, and that's a $2 billion fund to start with. What that does and how you can participate in it is, if you're an LP, it gives you, investment opportunity to co-invest with the government of India in impact investment. As a GP, the structure is malleable enough that if you're a third-party fund manager and you can raise the rest of the 51% for investing in India, the government will, if you satisfy the objective criteria, the government will give you the rest 49%. Or if you show deals to the government, they will commit the 49% based on which you can raise the rest 51%. So it's a great opportunity. I'll try and explain this. So it's not a blind pool structure. We're using the AIF regime. So again, support for the AIF regime. The government itself is using it. Within the AIF, SEBI's allowed us to create various schemes, similar to how a mutual fund works, where you can have various schemes, and you could have, let's say, a sub-scheme within an IIF where the Japanese put in $1 billion, and Ministry of Finance puts in $1 billion, and the Japanese say we are interested only in roads in India, and it becomes a India-Japan road-focused sub-scheme of NIIF. And they say, what, Morgan Stanley has, just as an example, the relevant experience in the sector, and they get Morgan Stanley to manage that money. So that's just the breadth of the possibilities in the structure that I'm talking about. Or they could create their own investment manager, hire their own people and get it to manage it. Or it could be a multilateral fund where it's focused on Indian Railways, where the NIF team itself finds 4 or 5 projects in railways which look attractive. The only bottom line for raising these schemes are they all have to be commercially viable, even though it is Ministry of Finance money, and to a certain extent based on impact on the economy, but it is supposed to be commercially viable. So minimum of, I don't know, like a 10% IRR in USD terms is probably what would be reasonable to showcase anything to the Indian government. And if you have, so that's if you're an LP or a GP, or even if you have portfolio companies, if you're consultants and you have people looking for exits, or other promoters looking for investments, the government's looking at raising these various schemes. The NIF team, the CEO has just been appointed. He's ex-IFC head of natural resources and energy. He's moving from here to India to head this up. They've hired a heavyweight to kind of pull this through. So the team is getting in place, and they could look at if you send through a portfolio investment, and we can help you put it in front of them. If there is a particular company that you think is going to benefit from investment, or is looking for exit for investors, and can meet the kind of minimum IRR threshold, then that's another way that you can utilize the scheme being launched. It's quite in its early stages, but there's a
lot of focus on getting this going. So we're expecting the first scheme to be launched anytime this year. And the focus, even though it's on infrastructure sector, it's not restricted to infrastructure. So in fact, the deal with the Russians is for a defense sector fund. So, it could be manufacturing, it could be, as long as the Ministry of Finance sees that it is helping boost a particular sector in terms of making in India or investments in India where investments are required, they are happy to look at it.
Yeah. So thank you, Pratibha. I think, I know after a long flight, it's not easy to explain complicated structure. But you've done a wonderful job, and thanks. I think this structure really has become kind of a benchmark or inspirational structure for many other countries in the world. And this is what was the award-winning structure as well from Financial Times. And it gives a lot of flexibility. It can provide a lot of ingenuity to cater to different sectors and different geographies within India. But I think this is very interesting, and thank you so much for briefing us on that. Very quickly, can we move to the next panel? There's supposed to be a break, but do you want break or we want to? You need some break? Okay. All right. Then we can have about 15 minutes break, and just 15 minutes, hopefully. That should be good enough so we can all get together. Thank you so much. Yeah. Appreciate your coming, and please come back very quickly.